Good afternoon, ladies and gentlemen, and welcome to the session on planning ahead the what and why of wills. We had a little technical problem with our sound to begin with, so I've already said a few things. I'll start again. I'm Chris Stone, a team leader in the Legal Information and Advice Division here at Legal Services, and with me is Mark Rubeo, who is one of our senior lawyers in the Legal Information and Advice Division. And this is National Advanced Care Planning Week. So one of the important things about advanced planning is the issue of wills. So we're going to be talking about that today. Importantly, there was a new piece of legislation or an Act of Parliament that came into force at the beginning of this year, the Succession Act of 2023. Yeah, it's dated 2023, but it only has just come into effect. So we'll be mentioning some of the changes brought about by that. Can we start by acknowledging that we are meeting on the land of the Kaurna people, and we respect and acknowledge the traditional owners and the past and present and emerging leaders of that community. Another technical issue here, folks. We're just working how we can move the slides. There we are. Sorry, folks, we're getting there. So we've made that acknowledgement. A bit of housekeeping. Please use the chat function in Teams if you do have any questions. Hannah is here with us to monitor those questions, and she's going to feed those to us. If you do need technical help, again, please use the chat function in Teams to let us know about any problems like sound that we've already encountered, or indeed if something else appears wrong. If you need a certificate to prove that you attended this webinar, you can obtain that from us. Please email cle@lsc.sa.gov.au. I suspect many of you would already have that email address. Okay, wills in South Australia. As I mentioned, the Succession Act of 2023 commenced operation on the 1st of January this year. It replaced 3 Acts of Parliament, or 3 pieces of legislation, some of them very old, as you'll see on the screen there. There was a Wills Act 1936, there was an Inheritance Family Provision Act 1972, and there was an Administration and Probate Act which went back as far as 1919. So all of those have been brought together in the one piece of legislation, or the one Act of Parliament, the Succession Act of 2023, which is now in force. Now, this doesn't mean that any wills created before the 1st of January are no longer valid, or it doesn't affect their operation at all. There might be some changes, though, to what happens once the will needs to be put into effect, and we'll deal with those issues as we go. So what we're going to cover in today's chat: what is a will? Why should you have a will? And how can you go about creating a will? I should point out that Legal Services does have a very good series of fact sheets, information sheets on this topic, and we'd encourage you to have a look at the Legal Services website, and if you follow the links, you'll find a tab for publications, and that will get you to links for all of these fact sheets, which are all up to date and which will go into the matters we're discussing today, perhaps in a little more detail. So let's talk about what a will is. It's one of those things that can be used to ensure that you have a voice and that your wishes are upheld. It's often thought of at the same time as people are thinking about advanced care directives and when they're thinking about enduring powers of attorney. There is a distinction here, though. Advanced care directives and enduring powers of attorney are relevant to your circumstances before you die, they cease to have effect once you die, and then after your death, the will comes into effect. So there are three important documents. Two of them are relevant to while you're still alive. One is very important to the situation after your death and important to your wishes being upheld. And it's that third one, wills, that we're talking about today. A will is a legal document that sets out who you want to inherit your estate, and your estate can include various things. And you can also set out your wishes in your will about your funeral, how your funeral is going to be carried out, for instance, and other such things, such as your preference for arrangements for your children after your death, and even who might care for your pets. The law does, in fact, treat pets as your property, so they do form part of your estate. So, Mark, I might bring you in here.
Sure.
In terms of what makes up someone's estate. And on the screen, we've referred to your money, your possessions, and your property.
Yes, an important thing to keep in mind is that what forms part of your estate is what you own. Now, that might sound obvious, but say, for instance, you own a house with a spouse or your partner or whoever else. If that's owned jointly, that will not form part of your estate. That property will transfer, or at least will go through to the person who is the survivor. So quite often people will ring and inquire about that and not know until that point that that major asset is not something that can be given and passed through to someone in the family or wherever as a result of it being jointly owned. So we're looking at things like that you've got in your own name. You might have money in your own account. If, again, just to keep in mind, if it's in a joint account, then the person that is also listed as the other party will have that ability to go and have access to that money. So it's anything and everything else. Might be a collection of things that you have, something that a family member has had their eye on and has an interest in, that you've shared an interest in. It's also things about your funeral, anything to do with anything in particular that has a sentimental aspect to it. So they're the main things, but the things that can't go in your will, I suppose that's an important thing to distinguish. We've already talked about jointly owned, but debts and liabilities can't be inherited, which is a relief. But the estate is responsible for it. But superannuation is another aspect. And that's important to know as well, because a lot of people think super will go into the estate and then be distributed. So that's a very important thing to keep in mind.
So my understanding, Mark, is that superannuation funds also often include a death benefit, and it's an issue of whether you've nominated someone to receive that death benefit or not.
That's right. Yeah. So it's very important to have all those things looked into, and to not only just have your will prepared or turn your mind to it, but those other aspects, because otherwise you what you think is going to happen won't in fact happen after you pass away.
Well, I guess that brings us to the issue of do I need to have a will? And for instance, one might say, well, my family knows what I want. They know what to do with my assets. Or you might say, I don't have any assets, or You might even say, well, I have family members, but look, I don't have any contact with them. Or I just want everything to go to my partner. Now, they'll get everything, won't they, if I pass away? Or
Yeah.
even, as you can see on the screen, in my culture, there are rules about how somebody's property should be distributed after they have died. Now, those are things that do come up from time to time. And I think the thing we're trying to emphasize is if you want a certain result in relation to your estate, then that is a very good reason to have a will. And perhaps to demonstrate that, what we need to look at is, what if we don't have a will? So if somebody dies without having a will, that's what's referred to as dying intestate. And the estate is distributed according to law and not according to their wishes. So it's all very well to say, well, my family know what I want, but if it's not set out in a will, then there is law about who gets what. That's all now contained in the Succession Act. So let's move on to that one. And there are a lot of detail about this, but we're going to try and cover it in a very broad sense. So, Mark, you've already indicated that if somebody owns property jointly with a partner or spouse, then that property automatically goes to the surviving partner.
Yes.
That's not part of the estate. So that can apply to a home that you own jointly. It can apply to a joint bank account and any other investments or properties or property of any sort that is owned jointly.
Yeah, that's right.
Yeah. That then leaves any property that's in your name only. And in the case where there is no will, then the legislation or the Act of Parliament that we're talking about sets out an order in which that property goes to people. So, Mark, there is on the screen there I guess a series of relatives or relations who can benefit, but it very much depends on the situation, doesn't it?
That's right. And I suppose one of the things to keep in mind is that, you know, on the face of it, you could say, oh, well, looking at the order there, spousal, partner, children, natural and adopted, grandchildren. If you look through it, it's, you know, it's a logical, and on the face of it, it's a fair order. But the thing is, it doesn't take account of, say, a child with higher needs.
Mm-hmm.
What happens if you're separated from your spouse but not divorced, or you want to give it to charity? These are things that this doesn't cover. And again, it highlights the fact that if you don't have a will, you don't have a voice. And without that voice, it's going to be left to this, you know, it's a fair way of doing it, but it's the fairest way in the absence of the knowledge of what that person intended.
Sure. Now, it's not the case that each of the people that are listed on there, so if I passed away, it doesn't mean that my partner and my children or grandchildren and parents, if they're alive, and sisters and brothers, etc., all get a share.
No, that we should highlight that.
Yeah. Perhaps we can move to the next screen and give an example. So this is an example of someone called Shannon, who passed away without a will. Shannon left a spouse and 2 children. Now, they had a home. It was jointly owned. So that automatically goes to the surviving spouse, Shannon's surviving spouse, and it is not part of the will. The rest of the estate or the estate consists of $130,000 in a bank account, and that was in Shannon's name only. It wasn't a joint account. So that amount of money has to be dealt with according to the order of the intestacy order that was on the previous screen. Now, one thing to note is that part of these rules means that that the spouse ranks first to a certain degree.
Yes.
So previously, the first $100,000 of an intestate estate went to a surviving spouse. That's being increased in the new legislation that's now in force to $120,000. So in this scenario, we've got $130,000 in a bank account. So the first $120,000 goes to Shannon's spouse who survives Shannon. That leaves $10,000. And the details of the legislation indicates that after the $120,000, whatever's remaining is divided up, half going to the spouse and the other half going to their child or children equally. So in this instance, there were 2 children plus the spouse. So Shannon's surviving spouse gets the first 120 and then half of the remaining 10. So a total of $125,000. $2,500 goes each to the children. That's a relatively straightforward situation, but you can imagine where there are more children,
definitely
no children, and indeed where there is not a spouse or there is not children, that's where that list comes in. We'll go back again, and that's where then it's a matter of going down the list to see what there is in terms of the distribution of the intestate estate. Now, it may be that Shannon had no intention or no desire, for instance, to benefit others. But depending on the situation, of course, Shannon might have ended up benefiting first cousins if there's no other choices.
That's right. And you can see that that asterisk next to the final category has been an addition as a result of the new Act. But that's quite a way down the list, children of first cousins.
Incredible. Yeah, that's right. So it can get complex. I think we have to be clear about that. And ultimately, if there's no relatives that an intestate estate can go to, so if someone dies and there's no spouse or partner, no children, and none of the others that's referred to on that list, ultimately the money will go to the state, that is into the government coffers.
That's right.
So I guess
that might be a pretty good incentive to remind people that do you really want that to happen? I mean, you might feel a connection to your state, but that's quite a gift.
It might well be in some cases. So even those that do not have a spouse or partner or do not have relatives as listed, they might want to consider where their estate goes. They may want to benefit a charity, for example, rather than it going to the state coffers. So that's again, right. That's something to consider. Moving on, we do hear stories from time to time about how wills have been prepared in very unusual circumstances. And there's a reference on the screen there to a real life case in the UK, where a man had written his will out on the back of some frozen food boxes. It looks like fish fillet boxes. And
they must have been his favourite.
Yeah, I suspect so. Fish and also mince pie boxes, we're told. And the money was left to a charity, and there was a challenge made about that. But ultimately, we understand that a UK court upheld the fact that this man left his estate to Diabetes UK. We're not encouraging that people follow that example, but there is the issue of what do you need to do to create a will? We'll come shortly to how you go about creating a will, who you see or how you do that. But
I think the main thing that comes from that example, though, is I know it's something you'd never forget, and there are lots of cases where there've been some very obscure and interesting facts, but it's the time and the cost to the estate of having to then establish that it's a valid will, and that's the whole point of that example. As sort of eccentric as it may seem, it ended up costing the estate a lot of money to enable that to be proved as a valid will. So that was money that could have gone to the charity and instead went towards having to prove that, and it's a very particular and pedantic process.
Indeed. Well, and to that point about how particular things are in relation to creating a will, there's a number of things that are required for the will to be found to be valid. First of all, a person must have legal capacity to make a will. Now, it may be that we all have a general understanding of what legal capacity is, but Mark, what are we talking about when we refer to that?
Well, we're talking about understanding what that person is doing, whether they have some idea or at least the mental capacity as well. There may be a sign of dementia. There may be pressure from other family members, things like that, and we need to make sure if we were to see someone in that situation that they haven't been unduly influenced or pressured, that they are able to understand and they're cognizant of what they're wanting to do, to see that person on their own.
Yeah. So essentially, the person who's making the will has to understand what the will is, the nature of the will, what its effect will be, and that there's also issues about them signing it with their free will, so to speak. That's an issue about the validity of the will. But first, for a will to be valid, yes, firstly, the person needs to have legal capacity. A will needs to be in writing, as we just said. Yes, sometimes a will has been written in very strange circumstances, including on the food packets, as we just saw. And as Mark indicated, there's been cases over many years in many countries about strange wills. Most lawyers know of an old English case where a will was written on an egg, a very big egg, which was found to be valid. Again, we would not recommend going down that path.
No, even with Easter coming up.
Indeed. So a will has to be in writing. It has to have clear and identifiable beneficiaries, and it needs to be signed at the end by the person creating a will, indicating their clear intention to create a will. It also needs to be witnessed by two adults. They don't have to be any special sort of person. They don't have to be a lawyer or a JP to witness a will, but they do need to be adults. It is, I think, preferable not to have beneficiaries witness the will, if that is possible, to have two independent people. So, for instance, you could get your neighbours in, and if wills are being witnessed in lawyers' offices, it's often a couple of staff members in the office.
That's right.
Who do that. In years gone by, I've did that on many occasions where colleagues were preparing wills for clients. If the person who's making the will, who we call the testator, has a difficulty signing it, there are ways around that. The witnesses can indicate that the person made their mark, for example. So there are ways around that which can be dealt with. But those are some of the technical requirements for a will. A will has to appoint at least one executor. It's quite common to appoint more than one executor, quite common certainly to appoint two executors. Again, an executor has to be an adult, and they themselves need legal capacity in order to carry out the wishes of the person making the will. So this, I guess, is where we come to what the executor does. And that's something that we often get asked, Mark, by people ringing our legal helpline, for instance. What are the executor's duties? And we've got listed at least the main ones there on the screen.
Yeah, and the big point to highlight is that since 1st of January this year, there is now a positive duty for the executor to allow people to view and take copies of the will. That was it was an issue that that has always been a bone of contention. A lot of people would ring and say, well, I'm not allowed to see the will. And of course, this is after the person has passed away. You don't have to show the will to anyone while you're alive. That's the right of the person making the will, to have that private. But the executor must allow that will to be viewed and for copies to be taken. And so because of that positive duty, that anyone acting for other parties can exercise that. For instance, if they're not fulfilling one of the duties, then we've listed them on the screen, well then they can be sent a letter at first instance saying, well, if you're not complying with your duty, we're putting you on notice that you could be replaced.
Indeed. So it's a lot of responsibility to be an executor.
It is. And
it's certainly a very good idea to have a good discussion with anybody you are thinking of naming as an executor. You certainly shouldn't execute a will and name an executor without that person's knowledge.
No. I mean, it's something that theoretically you don't have to, but it doesn't make sense in terms of any practical application. You want to make sure you've got that relationship with that executor, so you feel they know you, they get you, and they'll carry out what is in the will.
Yeah.
So in the way you want.
Yeah. So the duties include the things listed on the screen there, and it might vary in some circumstances. The executor should be able to locate the original will that's being signed. As Mark says, there's a new responsibility that if certain people, and that's again listed in the legislation, but certainly relevant to family members and certainly beneficiaries, are now have a right to look at the will and indeed to have a copy of the will. That did not used to be the case. Usually it's the executor who organises the funeral and indeed can make decisions in that regard. Usually it's the executor who obtains the death certificate or a certified copy of the death certificate. If there needs to be an application for probate, then it's again, usually it is lodged in the name of or by the executor, or indeed by a solicitor who may be instructed by the executor.
And the word probate is a legal term for proving the will and then getting a grant so that the executor can carry out these duties with that legal authority. Yeah.
Indeed, yes. So it doesn't mean the executor has to do all of that themselves. It is quite common to instruct a solicitor to do that in terms of applying to the court.
Yeah, so it can sound, well, the duties are considerable, especially if you were doing them on your own. So that's why it's important, if it can be done, to have someone else look at it and give that assistance. Of course, it depends on the estate, the size of the estate.
Yeah, and one thing that we've indicated already is that this area of law is sometimes a very technical and very detailed area of the law, and applications to the Supreme Court for probate have to be done correctly.
Oh, yeah.
Traditionally, it's being an area where the court has been very fussy about how applications for probate are prepared and worded and drafted. That's changed a little in the sense that, like many courts, certain things are done online these days, but nonetheless, the court still has certain requirements. So getting it done properly is it sometimes will mean it's worthwhile instructing a solicitor to do that.
Yeah, well, remember we were talking about the days when putting a paper clip on the will, they'd see the mark, and then
Yes.
there'd be if it became something contested, then what was attached? Was it something in addition with a different direction? That's the nature of how far these things go if it comes down to a dispute.
Yeah, the court will often ask questions where there are things like that, where there's been a paper clip or something pinned to the original will. They might raise questions about any part or any sheet that may be missing from the will. So it is it's an area where the court is fussy, to put it in plain words. So therefore, how do you go about creating a will? There are a few options. Of course, people can go to see a lawyer and have a will drawn up. I guess we should say that in most cases, that's what we would recommend.
Yeah.
Trustee companies, and in particular the public trustee, are often prepared to make a will for people. That's usually on the basis that the trustee, and including the public trustee, acts as the executor, and then there is charges on the estate upon completion of the job. We should make the point, I guess, that lawyers who prepare a will and lawyers who either act as an executor or carry out work for the executor are only entitled to charge fees based on the work they've done. They're not allowed to charge on the basis of a percentage of the estate.
No.
There is the third option of what we refer to as do-it-yourself will kits, which can be purchased from various places. They can be risky if they're not properly prepared. As we've indicated, this area of law can get down to very close detail, and there can be questions raised about whether the will has been properly executed. And as we've indicated previously, if you make a mistake, you're not ending up with the result that you wanted. If you haven't properly executed the will, for instance, using a do-it-yourself will kit, it would be the same situation as if you had no will at all.
Yeah.
And that means those rules about intestacy would come into effect.
So it's a big risk if you especially if you have specific, specific ideas as far as what you would like, and assuming family will know, but that is not something that you could ever rely upon.
That's correct. So one might ask, if I have the will done by a lawyer, does that mean it's watertight? Does that mean that no one can contest the will? Well, not necessarily. We'll turn to the issue of contesting a will. I like the illustration of two stags fighting, and sometimes that's what happens with families after a member of the family has passed away. There are a couple of grounds on which a will can be contested. But firstly, it should be pointed out that there is a time limit for doing this. Essentially, you've got 6 months after a grant of probate or letters of administration. So we've mentioned probate. Letters of administration is similar to probate, but that's in the situation where there is no will and there's an intestacy.
Yes.
And that's where you have to follow the rules about the order in which people get things, which we discussed earlier. But essentially, there are 2 grounds on which a will can be tested. The first is that the will is invalid. The second is that the will is unfair. So the will being invalid, on what basis could that be, do you think?
Capacity.
Okay.
That's usually the main argument, that the person that signed the will wasn't cognizant of what they were doing, or had medical impairment of some sort,
Okay.
that meant that they weren't able to really know what they're doing, and forced into doing something that was not really what they intended.
Sure. I guess there's also the possibility that if it is a do-it-yourself will, either using a do-it-yourself kit, or it's a will written on the back of a food packet that we mentioned earlier, it might be argued that it's unintelligible.
Yes.
That it's not clear what the person writing the will wanted, and therefore it's not valid.
Yeah, so the actual content of the will is just being drafted in a way that means that you can't get any clear understanding of what there might be, the contradictions, other things in it that just don't make sense. And unfortunately, that will result in the will not will result in it being declared invalid,
and therefore it becomes an intestate estate, and we go back to those rules.
Yeah.
So the other ground on which a will can be contested is essentially that the will is unfair, and that's a situation where somebody says, I haven't benefited from that will, I should have benefited from that will, and therefore it's unfair. Or I have benefited, but I should have benefited more than I did.
Yeah.
Those are the two bases for the will. Where somebody was arguing that situation, we're talking about what we refer to as a family provision claim. And again, the legislation that most of this discussion is based on, the Succession Act, sets out categories of people who are eligible to contest a will on the basis that they weren't adequately provided for. So it's not just anybody who can say, well, Mark's died. I was a good friend of his, and I think he should have left me some money.
Yeah.
I don't qualify, do I?
No.
So listed on the screen there are, again, various categories of family members who may be able to contest a will on the basis of unfairness. It is worth noting that there have been some changes to the details of who can contest in those situations.
They've curtailed the scope, because before there were so many applications that were made that really didn't have any merit or little merit, and the cost of all that was prohibitive. So some of these categories have either are more defined. The only one it's interesting, if we look down the list, with stepchildren, those circumstances have widened because in the past they weren't. It wasn't as easy to have them included.
Okay.
Yeah.
So on the one hand, there have been some restrictions from the previous legislation, and on the other hand, there's been some widening.
Yeah.
What should be emphasised, though, is that if anybody were considering challenging a will on this general idea of it being unfair, they need to get very good legal advice.
That's for sure.
So we're covering this in a very general fashion. It should also be emphasised, however, that there is no guarantee that someone challenging a will in this way will succeed. The court will, and this has been emphasised in the legislation that is now in effect since the beginning of the year, that the wishes of the deceased person are the most important consideration.
Yeah, so that's the utmost consideration, front and centre, when a court decides anything. And then the other aspect that's interesting is that courts can ask for money to be paid in terms of any costs issues, and that clearly is going to have the effect of if people were wanting to make a claim, they're going to have to do something more than just say, I want to make it and get things filed. They might have to pay money in to the court.
Yes.
And that is certainly going to test whether something is more genuine than not.
Well, historically, there have been cases of this sort that have very sadly have eaten up the estate in legal fees because of the dispute. And that change has meant that in some cases, the person challenging the will on the grounds of fairness or unfairness may have to put the money where their mouth is, if that's the right expression, and may be at risk of paying costs. But again, we emphasise that anybody contemplating this would need to be getting very clear and very expert advice on the matter. We're coming towards the end of this presentation, but we should make it clear that that changes in people's life circumstances can impact their wills, and also might cause or should result in the will being reviewed. So, for instance, one thing is if you marry and you have an existing will, then that will you've had is invalid. You need to do a new will after you get married. Similarly, if you get divorced, that may have an impact on at least some of your will. It might invalidate certain provisions of it. So changes in circumstances, such as marriage and divorce, and even the passage of time, may mean that your will should be reviewed, if not redrafted or doing a completely new will.
Like a executor, for instance, that you may have chosen, and that executor now, they may not be mindful to have the ability to carry out those duties as they may have when you were appointed.
I may have appointed an uncle to be my executor 20 years ago, but my uncle has since passed away.
Yeah.
And therefore, if I died now, there'd be no executor named in the will. And that's an extra complication for my family once I pass away. Simple changes like changing your address don't cause the will to become invalid. That's something that people ask us about from time to time. And just because you've got a new address from the time that you created your will, that doesn't in itself mean that you need to change the will at all.
Yeah, I remember there was that also, because it's the identification, isn't it? My sister, even if your sister's name has changed.
Thank you.
It's if you identify your sister and you've got one sister, well, then that's clear. That's not going to make the will invalid.
Yeah. So we are coming towards the end, but I've just been told we do have a question on chat from Leanne. What if I don't have someone to nominate as an executor? Who else can perform this role? Well, an obvious situation or an obvious option there would be the public trustee. Could act as your executor. That would involve the public trustee preparing your will, and it would involve them acting as executor. And yes, they to take a certain charge. It's not unusual, however, for people to have a will prepared by a solicitor and for that solicitor to be named as an executor.
Yeah, that's an option.
One or more of the solicitors in the firm in question, for example, could be named as executors.
Yeah.
So those are two options that come to mind immediately, Leanne. We've covered a bit of ground here about wills, and necessarily in a very general fashion. Can we emphasise that we do get asked a lot of questions of a general nature, and that we can answer a lot of them via our legal helpline 1300 366 424, or indeed our online chat facility. As it says on the screen, our legal helpline can provide general and preliminary advice and also referrals. And legal chat, which is accessible through our website, can also help with quick legal information. Again, we'd encourage people, if they're interested in this area, to have a look at the information sheets on our website. They go into a lot of detail about the subjects we've discussed. Also on our website, there's the document that's currently on the screen, an end-of-life planning checklist and worksheet. And it's useful, I think, to provide to one's relatives, not just elderly relatives, but it's a useful thing to look at things to think about, which will certainly help people in the event of illness or end-of-life situations. And so we've come to the end of this presentation. Thank you for joining us today. There'll be another in the community law for community workers course in the near future, and there'll be information about that distributed by email in the very near future. It's still okay. We're just folks, we're just catching up on a couple more questions.
Shall I answer this one, Chris?
Yeah.
Someone's written or sent a question: who can be an executor?
I think that's who can't be an
executor. Oh, who can't be?
Yes.
Oh, I didn't read that. That's who can't be an executor. Well, someone that's under 18 can't be an executor.
Yeah. So you need legal capacity yourself.
Yeah. And legal capacity.
And that means not under 18. Somebody who lacks legal capacity themselves. So, for instance, somebody who's unable to prepare their own will, or unable to prepare other documents such as a power of attorney, an advance care directive, and so on, would not be able to carry out the role of an executor.
But otherwise, really, anyone else can.
Yeah,
so it's
someone that you have confidence in, though, is the best answer.
Yeah.
Someone you have confidence in who will carry out your wishes and carry out the duties of the executor that we've indicated after you've passed away. If you don't have confidence in that person, and if you can't think of anybody that you would have such confidence in, then maybe the alternatives, such as a professional person like a solicitor, or indeed a official trustee such as the public trustee.
I think that's why it's almost best to speak to someone who you've got in mind, because it's quite an onerous responsibility otherwise.
Just looking at a couple of other questions quickly. What if someone's witnesses on their will have passed away? Is the will still valid? Yes,
it is.
Yes, is the short answer. I guess there might be a practical issue if someone were to challenge the will on the basis of whether it was validly executed. But the fact per se that the witnesses have passed away does not of itself invalidate the will.
And I think there's something I don't think we covered this, but any will before 1st of January this year is still valid, even though it's a new act. So that's just something that, just in case someone is thinking about that aspect. That has no bearing on it.
Yeah. There's a question also about in First Nations circumstances, is there a specific program that can support them with this process? Now, I have to say I'm not aware of a specific program, but I do know that there can be specific issues with First Nations people in relation to arrangements after death. There have been some cases where the manner of their burial or the disposal of their remains has been the issue of some dispute. That can happen in any context, of course, but I am aware of some cases where there have been concerns about that, and therefore the matter has had to go to a court to determine that dispute. Look, I think the only thing I can say there is that it is also important for First Nations people to have a will that expresses their desire in relation to their estate and in relation also to the details of their funeral and how their remains are to be dealt with, because it can be a matter of some dispute. But the issue of whether there is a specific program that will support them through that, I'm not able to answer that.
No, I'm not either.
So I think that's all the questions that we've got coming through. Once again, thank you for your attention today. As we've said, it can be a very detailed and complex area of law, but we do encourage people, where appropriate, to seek at least preliminary advice with us, Legal Services, and if need be, we can refer people further for more detailed advice. So thank you once again.
Thank you. See you.